Hi, Mr. Guy.
How you doing? Lauren, are you taking this test?
I am taking this test.
I did not know that.
What? I told you I was.
I thought it was only the econ test. Oh my.
No, I'm taking both.
All right. Let me look at your essays and review your essays.
Oh, okay.
I'll look at those and see what we're doing on that. So I want to look at those.
How are you, Mr. Guy?
Good. And you? How was your mom's day?
It's good. It's also Brandon's birthday today.
Nice.
Yeah, how's your Mother's Day?
I miss my mommy, but it's going good. I've been trying to take care of my wife, and we're gonna actually see my son next week, so we're gonna do something then.
Oh, that's exciting.
Mm-hmm. Yep. So how's everybody else doing?
Good.
Good?
Yeah. Just
Good.
hanging out.
Anybody do anything fun today?
We made breakfast for my mom, but that's about it.
What'd you make? You didn't pick up McDonald's for her?
I'm so sorry, Lauren. We did not pick up McDonald's for her.
What the?
Me
I know Scott did for his mom.
Nice.
Yeah.
Exploding Cat is right here, so.
Oh my god. I would literally die for Exploding Cat.
I don't know. Exploding Cat is coming right here. Right here. So is everybody ready?
Absolutely.
Not even close, Mr. Guy.
What?
I'm kidding. Of course I'm ready.
Ben, you're gonna get a 5 and you know it.
Lauren, no, I will not. Trust me.
You have to have faith in yourself, Ben.
I know. But I don't, so that's good.
Well,
I'll be
I have
looking,
faith in you, so you'll
I'll
be fine.
looking for
Thank
some.
you, Lauren.
Like on the argument essay, they're no longer wanting you to refute anything, so they're not doing that. So you're going to have the argument essay first. The constructive essay, they're probably going to mention a Supreme Court case and have you compare like you did in that one that we did about Citizens United versus the Johnson Amendment. So they're probably going to sneak at least part of that in there. So make sure that you know your documents. The documents are important for the argument essay. And then the Supreme Court cases can be a thing for your argument essay. Plus, I do believe, obviously that they're probably going to have some Supreme Court case part or question in that second essay. Now, the second essay will be some kind of scenario, some kind of thing where there's two interactions between the branches, and they're probably going to have something about the Supreme Court or maybe something on the bureaucracy. So figure, you're going to have your required documents right there with you for the first essay, have your unit 2 there for your second, and then unit 3. They're not going to ask anything on unit 4. So they should not ask anything about Citizen United because that's in number 5, but they might ask you something about Citizens United in that last one where they compared it to the Johnson Amendment and that kind of thing. But they shouldn't be asking you anything on that one. It should only be the 14th because there shouldn't be anything on Unit 5. On the argument essay, you need to basically take a side. Don't make up arguments. Don't make up theses. So when I look at this one, and I'm going to share it with you, if I can. Come on, Exploding Cat. Stop it, Exploding Cat. All right, so share. I'm going to go here. So on this, no, I don't want this one. We're going to go over that one together. On this one, develop an argument about whether expanded powers of the national government benefits or hinders policymaking. I got a lot of students going that it hinders policymaking because it hurts the states. That's not what the question's about. This is expanded powers of the national government. We're only talking about the national government. We're not going to be talking about states. Now, if it's a federalism one, it might say something with that, but this is about national government benefits policymaking or hurts them. Now, I can argue that the expanded powers of the federal government, national government, hinder policymaking. And one of the things you can see right now is with a strong president, with the Supreme Court, nothing's getting passed, nothing's getting done. So I can see right now with political parties, with strong separation of powers and checks and balances, we don't pass any laws. Under Truman's do-nothing Congress, we used to pass about 800, well, actually we passed about 1,000 bills a year. The do-nothing Congress passed 800 bills in a year. Currently, right now, we might do 5. And then the rest are basically naming monuments, naming post offices, doing that kind of cheesy stuff, joint resolutions. So typically you can say, because of the way we're straight up now, that our expanded powers have hindered policy making, but it's at the national level, not at the state level. So then you've got to use these situations, and they're not perfect. So they're not exactly perfect and fit for your answer, your question. So you've got to look at the articles. Now that one seems to be much better because it was a failure. So the Articles of Confederation couldn't tax, couldn't regulate commerce, couldn't do those things. So with expanded powers, it made things easier. It was easier to pass laws for the national government. It was easier to regulate trade for the national government. It was easier to, raise a standing, not even a standing army, but to raise a militia. If you were going to use hinders national policy making, you could use Brutus I. Got to know the backgrounds of these, these cases. Can anyone tell me about Brutus I? Can anyone tell me what it said?
Didn't it say that, like, if the government's too powerful, that nothing will ever happen and the strong national government will destroy state governments? I just remember when we read it, some of it actually turned out to be true, and it was talking about how, like,
Right.
nothing will happen.
What didn't happen is it didn't destroy states, but he was very afraid of that. He was afraid of the necessary and proper clause, which basically said Congress can make any law about anything, which is close. And it has been used to expand the power. The power to tax could take away your liberty and do this. And we've seen taxes a very big power. The Commerce Clause is big. He was also afraid of the judicial branch. And the judicial branch would wipe out state laws and wipe out state decisions. And when you look at, flag burning, every state in the Congress actually had a law against flag burning, and the Supreme Court wiped them all out in a 5-4 decision. Only one state, basically, I think it was Massachusetts, had gay marriage at the state level. Everybody else marriage was between a man and a woman. And that was wiped out by the case. So he was kind of right. Now, he didn't say a lot about the president. So in that one essay, it was about a strong executive and about impeachment, but he was worried about the president being too powerful, controlling the army, the militia, having a standing army, too powerful. And then with the other problems, there was an issue there. Can anyone tell me about Federalist 10?
Was that
Isn't Federalist 10 about like the government gets too big and it won't have enough representation for the states?
Federalist 10 is about factions.
Yeah.
About
Factions.
If there was a bigger republic, then factions wouldn't have as much power because no one could agree. So having a bigger republic is safer to ensure that minority rule doesn't happen.
Or no, not minority rule, majority rule.
Oh, okay.
Got to remember, they were minority. They were elites. They didn't want mob rule. So the only place that you could control factions and control mob rule in the different factions or political parties or interest groups was at the national level, not at the state level. At the state level, you can see there's one party rule, there's rule by large interest groups, things like that. So in the state level, things get passed easier, get passed quicker, different laws get done. National level, it's much slower, but realize each one of these, you've got to know the document and know what it stands for, what it's doing, because it's going to be there. Now, Federalist 10 is about factions, you know, and you can't get rid of their causes. You can't outlaw factions. You can't make everybody the same. So you have to minimize their effects. And
Yeah.
then let's look at, my cat's going crazy. On this one, we're looking at, I want to look at Federalist 51. What does that one say?
Was it checks and balances?
Correct. Separation of powers, checks and balances. Now remember, every Federalist paper is for the US Constitution. So it is for expanding the powers. It's for getting rid of the Articles of Confederation. It is for the Constitution. So it's for the Republic. It's for a more expansive national government. But it is stating that there's, you know, don't worry about it because there's going to be checks and balances. There's not going to be tyranny. There's not going to be, you know, a king just destroying your liberties and things like that. You're going to have equal branches, one that makes laws, one that's, you know, executes laws, one interpret laws. Now, obviously, the legislative was the most powerful, the executive less, and then the third one is the judicial branch. But know the differences between the two papers. Don't get them mixed up, and you know, you got to go through these documents. They're important to know. I've listed videos on each one. I would kind of look at those, go through your notes and see. This is the famous one that said, if men were angels, we wouldn't need government. Men are not angels, and this is why we need it. We need to protect people from the government and people from each other. So we've got to protect each, you know, all of this. Now, Federalist 70, what was this about?
Wasn't that one person in the executive branch so that it would be easier to like hold them accountable?
Correct. You wanted a strong executive, a unitary executive. This was Alexander Hamilton. The first two were Madison. This is Hamilton. Wanted, you know, you needed somebody to make quick decisions. You need somebody to be decisive, especially in foreign affairs and a war as commander in chief. And then the check on them is you had somebody to blame. They're the one person. And they were actually talking about, should you have a plural executive? Should you have a committee of 3 people to be the executive? And this was the argument, no, you don't need that. You need just one. What is 78?
Judges serve for life on good behavior in the judicial branch.
Correct. So they serve for life. They are a separate, equal, independent branch. So those are the ones that are for. Brutus is the one that's against. Make sure you know those. In most of the essays that I've been seeing, they're using some of these papers for you to do. And then Articles of Confederation and the Constitution and the Declaration. When you guys mention the articles, mention that what the powers it could do or could not do. You know, when you were saying in the essay that it was weak, tell me how it's weak. Describe, when you're in that argument essay and you're describing that document, really do describe it. Say what Madison says. Don't just say 51 is about checks and balances. Don't just say 10 is about factions. Go into what he was saying. Don't have to do a 5-paragraph essay, but make 2 to 3 sentences on what that document is saying to prove your point. So one of these documents will be required in that argument essay. So don't just say 51 is separation of powers and think you got the point. You don't. You have to use it in related to that prompt. Now the Declaration, I haven't seen many, but remember those are the natural rights, the right, life, liberty, and pursuit of happiness, and basically out of the list of grievances, and you know, all men are created equal. Know what it was, the different parts to it. And then the articles, remember what powers it didn't have. It couldn't tax, couldn't regulate trade, couldn't enforce laws, could not solve disputes. It could obviously make treaties, it could declare war, it actually created states. So it had some powers, could not raise an army. So it was dependent on the states. There were 13 sovereign states, and each state created their money. And then the Constitution used the different parts to it. Don't forget the necessary and proper clause. Don't forget the 14th Amendment. So when you're looking at the Constitution, it's all of the Constitution, including the amendments, when you're looking at. So make sure you know the documents. So we got those, and then the letter from a Birmingham jail from Martin Luther King. That's what we did in the last unit. And remember, he was trying to convince the sympathetic white preachers why waiting or going slowly was not good. So Lauren, tell us a little bit about the letter.
He was just saying that like any form of injustice or inequality is a threat to it everywhere, and that if they're going to keep trying to postpone their rights, then they're never going to get them. And
To him, wait means never.
Yeah, and he was talking about like not following immoral laws, because those are just like, he shouldn't have any obligation to follow them since they're so like harmful to them, and that it's better to disobey them peacefully.
Mm-hmm. Okay, so tell me somebody about Marbury versus Madison. What's the background of the case? What was the finding? What's the importance of the case?
Madison was something about, I know it gave the power of judicial review. It was like he was mad at a different person who was supposed to assume power, and so Madison was like, oh, haha, I'm going to not allow you to
So John Adams gave judgeships and gave appointmentships to people, and he did it from all the way towards the end of his term. And remember, at the end of their term, the lame duck used to be March 3rd, March 4th. So it was not, the election was in November, but he was president until March. So on the midnight of the last day that he was in office, he gave some appointments to people, and Marbury was one of them. Marbury got an appointment, and he knew he was getting one, but he didn't get it delivered. And Jefferson said, don't give them any more to these people. Don't give them their appointments. They don't do it. And Madison was the secretary of, at that time was in charge of that, and they sued each other. So he wanted his appointment, and Madison was like, no, you're not going to get it. It went to the Supreme Court, and it was about the Judiciary Act of 1789. So it was about that act. And basically, Marbury did not get his appointment. So he lost, but it struck down part of that act as unconstitutional. So basically that act was kind of like superseding the Article 3 in the Constitution, and the Supreme Court said parts of that act were unconstitutional, struck it down, and that's where you get judicial review. So the important thing is you get judicial review. The Supreme Court now has the power to declare laws unconstitutional. So that's one that you're going to have. Tell me about McCulloch versus Maryland.
Wasn't that where they could have a national bank, and they did that under the necessary and proper clause?
Well, the U.S. Congress created the bank, created it using the necessary proper clause, and many states, including Maryland, did not like that. So what did Maryland do?
They tried to tax them.
They taxed the national bank. So it went to the Supreme Court, and they were looking at, can you tax a federal piece of property? The answer was no. Were the implied powers part of the Constitution and allowed? Yes. And then the supremacy clause, that the laws of the federal laws supersede state laws. So make sure you know the cases, know the background, what they came up with, and then the important part of it. Now, Schneck versus the U.S., this was in Unit 3. What was that one?
freedom of speech. That was about
Did it expand or did it, what was the situation?
It was like during wartime, the guy was like passing out pamphlets, and the Supreme Court ruled that like that it like they were like, oh, you shouldn't speak out against the war during like this wartime, and then they went to the Supreme Court and they're like, nah, that's his freedom of speech.
So he was a socialist. He was a socialist. He was
Yeah.
trying to get people not to go with the draft and trying to disrupt, World War One. So it was World War One, and he basically, was handing out the pamphlets and saying, "Don't sign up. It's unconstitutional. Don't do this." Trying to disrupt the war effort. And his freedom of speech was basically restricted. Now, this was the clear and present danger rule that we no longer use anymore, but it basically says if the speech was a clear and present danger to government or processes or society, whatever else, you can't do it. It's one of the cases where you look at, you can't yell fire in a movie theater at that time. Now you say bomb in an airport or whatever you want to do that. But if it hurts somebody or it's in imminent danger, and obviously they're using this in wartime, and you're trying to help the war effort or stop the war effort or things like that. So that is Schneck. Now it took away people's rights and used the clear and present danger. Brown versus Board of Education, what is this case?
Overturned Plessy Ferguson because separate but equal is inherently not equal.
Correct. So students were basically, kids were walking past the local school, going to their black school. It was kids from different states. It was a class action. It was a unanimous decision. And they were basically using, they were using more, not necessarily science, but social science to basically determine that just anything that is separate is not equal. It's inherently unequal. You can't make it equal. And it was 9-0 and basically desegregated schools. But remember, always look at this and say, the president has to enforce this. President has to do this. Now, we were lucky that Eisenhower did with 101st Airborne. He did enforce this and use the military to actually open the schools to the young African Americans going to the schools. If they didn't do that, the states were ready to stop that. States were ready to close schools to everybody. They kind of saw that with the gay marriage. They were like, certain places in Kentucky were like, well, if they're going to make us do that, we're not going to give out any marriage certificates. In the South at that time were ready to close schools because they didn't want blacks and whites to go together. How about Baker versus Carr?
One person, one vote.
No.
Is that
It is. The big thing is gerrymandering or redistricting was never a Supreme Court case. They always look at it as that was a political issue. So the big part of Baker versus Carr, could the Supreme Court decide something like this case? And they did say it was a case that could be justicable, Justicable. So it was justicable. They could make a decision on it. Later court cases became one person, one vote. But this is the first one. And basically, I don't know how they did it, but they came up with numbers that these districts hadn't been changed since 1901. This is a 1961 case. So you had people that had representatives based on population that was like 50 years ago. So they really hadn't changed it. You had a lot of districts that were malapportioned. And malapportioned means districts of different sizes. So one district might have 10,000, another district might have 200,000. So that's malapportionment. What is Ingle versus Vitale?
This is my favorite one.
Go ahead.
Go ahead. Lauren, do you want to do it?
No, go for it, Savi.
Okay, so this is the instance where like a public school like decides that like, hey, we're gonna do this voluntary prayer every day, and the parents of like different religious backgrounds are like, no, you're not, and it messes with the Establishment Clause because it was like advancing religious belief, and because it was like the publicly like funded state institutions aren't allowed to like promote and like advocate for religion, and so they're like, that prayer is unconstitutional. And
So It was a non-denominational prayer. It was voluntary. And you are absolutely correct. It was the Establishment Clause, and they struck it down as unconstitutional. So this one was Establishment Clause. So this was like that. So with all of these cases, make sure you know the background, know the case, because if they're going to put a question like we saw in the other one, you know, the Johnson Amendment versus Citizens United, and we used to have an essay for you to basically, they would give you a Supreme Court case that was totally weird that you never heard of, and then compare it to one of the, you know, required ones. So that's why I'm saying just make sure you go through these, know your foundational documents, know your Supreme Court cases, because you can use that in the essay for the argument, and you can also, it'll probably be in the constructive one. What is Gideon versus Wainwright? This is my hero, so what's Gideon?
He couldn't afford a lawyer, so they were like, you can't have one. And he was like, okay, well then I'm gonna do this myself. And then when he was in jail, he was like, that is unconstitutional, you have to give me a lawyer. So yeah.
Yeah,
And
he
it
really
was a
did that.
felony charge, and it was, the state was like, no, we don't have to do it. The federal government does it for federal cases, but state does not have to. So this basically selectively incorporated the Sixth Amendment in that part to the states, because the state was saying, we don't have to do that. That's for Congress and federal laws. So Gideon versus Wainwright did the right to an attorney. And if one cannot be afforded, the state will have to provide one for you. Tinker versus Des Moines.
Yes, this is about the students and their free speech. You already know what it is. This is about the Vietnam War. Like, they wore the armbands, and like
Correct.
they were like, you can't do it inside of school. And
'Cause
then
it would disrupt school. So the whole idea
Right.
was this protest, all these students would be wearing these black armbands. They would disrupt the learning environment. And what happened?
it went to the Supreme Court, and they were like, oh, and they said that the students did have their right to free speech. And I think, I don't know what part of the First Amendment, I mean, like, what part of free speech it was like, I don't know, what the main.
What do you mean first part? Now, this was a symbolic speech. So this is one of the first symbolic speech cases, but it was freedom of speech. And they basically said, and this was, remember, the Warren Court, when you go to school, you don't throw away all your rights. And that was a comment from one of the justices. Now, currently, right now, that's kind of like what they believe is once you come to school, you have no rights. But at that time in the 60s, they said you could. And plus, wearing the armbands, I mean, you have students today that, you know, for gay rights and things will have their mouth shut and they won't say anything. They'll wear different colors and stuff like that. So we've kind of allowed this as long as it's, you know, silent and you don't say anything and you don't disrupt anything. So that was kind of like what they said. It wasn't really a disruption. New York Times versus US. What's that?
That one was when the U.S. had information about the Vietnam War. No, the New York Times had information, and they were trying to release it, but they said that they weren't allowed to because it was dangerous, and so it was a free speech case.
It's freedom of press. Freedom of press, and it's prior
yes.
restraint, which is censorship. And what really got me, it was a history of the Vietnam War from basically going back to Kennedy. So it went from Kennedy to Johnson to Nixon and what happened in the past and all the things that we didn't know. So it would make the government look bad. And it did make us look bad. But I really feel that if it was about Nixon and what he was doing that year or what he was doing at that moment, they might not have allowed it because that is executive privilege and it's something that they're doing right now. But because it was a history, because it was something that just looked bad for the government, but it wasn't going to hurt anybody. It wasn't going to hurt troops because the troops were already, you know, that was in the 60s and whatever else. It didn't hurt anybody. It wasn't a national defense. We need to keep this secret. They basically said, both New York Times, Washington Post, you saw that in the movie, The Post, with Tom Hanks, Meryl Streep, was about this case. And it's a prior restraint. It's freedom of the press. The government cannot, you know, censor materials. So it's a big one there. So this is a freedom of speech. How about number 10?
Wisconsin v. Yoder is about the free exercise clause, and it's an Amish family in Wisconsin doesn't want to send their like 14-year-old kid or something. Like they don't want them to get an education past the 8th grade. And the argument was that Wisconsin's like secular reasoning was that like, oh, we want all of our citizens to get a good education. However, because I guess it was like federal law, the Bill of Rights was like they have the freedom to exercise and practice their religion, so they don't have to go to school.
So it was a free exercise case. So remember, Engel versus Vitale is the Establishment Clause. This is a free exercise clause, and they sided with the Amish. So the Amish didn't have to do that at that point in time because of their religious reasons. So know the background, know what happened, free exercise. Roe versus Wade.
Roe v. Wade was about a woman's right to an abortion because of the privacy clause, and they ruled in favor of women having the right to choose that.
And it was, we needed, and it's not a required one, but Griswold versus Connecticut was the first one about birth control, because that was a state law that married people couldn't get birth control. So that one was struck down, and that gave them the right to privacy, the 9th Amendment. And then Roe versus Wade would then again use. Now, I've always asked, with the right to privacy, where do you find it? You find it in the Third Amendment. You find the right to privacy in the Fourth Amendment. You find the right to privacy in the 9th Amendment. And then I think some people have used with Roe versus Wade, equal protection, looking at that, men and women being treated equally and that kind of thing. Very controversial. Got to know the case, know the background, and then know what was used and what's allowed. Shaw versus Reno.
Wasn't that no racial gerrymandering?
Correct. So it was in North Carolina. So the first one was in Tennessee. Baker versus Carr. This is North Carolina. And even Sandra Day O'Connor thought it was a good intention, but it made a district just to have black people have a representative. So it was to give in North Carolina a black congressman. So that was the intent kind of thing. And they made a weird shape, weird thing. And they basically said race can be involved, but it cannot be the only determinant of making a district and doing that. So racial gerrymandering is not allowed, just on race only. U.S. versus Lopez.
Congress couldn't. Wait, this had to do with the Commerce Clause. They'd overstepped it, and they were like, you can't do that.
Correct. So gun-free zone. They used the Commerce Clause to say we're making a gun-free zone. So think about Brutus, worried about that implied powers. And it's a great law. It's a great idea, but it has nothing to do with commerce. And I would agree with the Supreme Court on this case. It has nothing to do with commerce, nothing to do with taxing. It shouldn't have been done. The state law was already there. The state had that law. That's fine. And then there was the other one was and it's not a required case, but U.S. versus Morrison. I always bring it up because if you think of Virginia Tech, that's where I went to school. That was where the football players raped the girl. And they had the Violence Against Women Act, and the Violence Against Women Act was used to give damages to the rape victims. Great law, great intent, but had nothing to do with the Commerce Clause either. So there are two cases that in that federalism chapter stop the Supreme Court stops the power of Congress. So you use McCullough versus Maryland, you use, the Civil Rights Act. You can even say, Social Security, Medicare is using the implied powers to expand the powers of government in doing this. But, McCullough, civil rights, Social Security, even Obamacare, you can clearly see that deals with commerce. It deals with industry. It deals with banking. It deals with regulating trade. Gun-free zones does not deal with trade. Sad to say, violence against women don't have anything to do with buying and selling anything. And we use Title IX today to protect women in college, to protect women for rape and those things, which is a totally different law.
If you look at women as objects, though, you can consider it commerce clause because buying and selling.
You are very true, and if you put that on your paper, you might get me to give you a point on that one. That one's true. So, I mean, that's absolutely true. You can pull out Dred Scott as your, precedent, and you can do that and say the whole thing. Then you've got McDonald versus Chicago.
That it's your right for state and local governments, like you can have a gun, regardless of what they're saying.
So,
There's like a handgun ban in DC, and I think they use that against him, right? In like the DC versus Heller case, like against him, and they're like, you
Well,
can't have it.
so DC versus Heller gave you the right to own a gun. So
Right.
the individual right to own a gun was finally done by the Supreme Court in DC versus Heller. All of the other Supreme Court cases up to this point, the militia was dealt with. So if it was a machine gun, you couldn't own it because it was part of a militia. They always dealt with the militia part. This Supreme Court says you now have a fundamental right to own a gun, but that was federally. So McDonald versus Chicago took that federal and applied it to the states, and applied it to Chicago and doing that. So now the Second Amendment is incorporated to relate to the states. So that one's there.
Was Chicago like, oh, this is a gun-free, like you're not allowed to have a handgun? Like that's what they were arguing.
No, I mean, even DC was not saying you couldn't own a handgun. What DC said was, if you had a handgun, it had to be taken apart and there could be no bullets in it in your home. So they allowed you to own it. They allowed you to have it, but in your home, you had to like disassemble it. And the guy that brought the case was a cop. And he's going like, I know how to handle my gun. I know what I'm doing. He brought the case and they agreed with the cop. And kind of like, that's the kind of person you'd want to say, I know how to handle my gun. And you look at Chicago, Chicago's always had the strongest gun laws. But the problem with Chicago's gun laws is Gary, Indiana is 5 minutes away. So that's what people do in Chicago, is they go to Gary, Indiana, buy their gun, and then bring it back to Chicago. And everybody says, look, Chicago's gun laws don't work. And I'm like, you're actually proving the point that we need a national gun law. Not that they don't work, but just if you do it locally, that's what's happening. I mean, right now, Florida is in lockdown. Georgia's not. Guess what people in Florida are doing right now?
Getting guns from Georgia.
Well, they're just going to Georgia. They're going there to go to the movies, to go to restaurants, go there because they're opening up. So you can see, I mean, when I was in Connecticut, we couldn't buy beer on Sunday. So guess what everybody did? They went to New York, drove to New York, got their beer, got drunk, and then drove back to Connecticut. It was like so stupid. But
the only acceptable reason to go to Georgia is to visit the Jimmy Carter Library.
And you must bring Jimmy Carter in every time.
Yes.
So Citizens United, they say it will not be on there. So we're going to just go over it anyhow. What's Citizens United?
Citizens United was about finance for campaigns, and it said that corporate broadcasters could not limit political broadcasting.
It was about Hillary the movie. So it was a movie about Hillary to make Hillary look bad. And it was right before the primary, Hillary and Obama and that kind of stuff. So it was in 2008. So it was like they were trying to get, and it's very fascinating how these things work. They being conservatives and Republicans, wanted Obama to win because they thought they could beat Obama, they couldn't beat Hillary. How things have changed. So they were afraid of Hillary. Hillary was very popular. The Clinton, dynasty, whatever else. So they were going to put out this movie right before the election to make people not vote for Hillary or, vote for Obama and that kind of stuff. So there's a lot of different things with this, but that was the basic thing. Citizens United was the group that was making the movie. So it was an interest group. And then with this, what was the holding? What did they find? Come on, Allie.
They were allowed to do it, right?
Yes. Obviously, 2 years later. So yes, they can do this. That part is allowed. They
Is
basically.
count as people or something?
Corporations and unions
Oh, have individual rights.
that they can give because money is speech, and you're stopping
Oh.
somebody's free speech by giving money to a campaign. So corporations and unions can give money unlimited to, interest groups and third parties. They're the super PACs. So I can't give unlimited money to Barack Obama or Donald Trump or Joe Biden, but I can give money to third party groups that will put out ads that will destroy the other side. So I can give money as much as I want to. I can give $1 billion. I can make my own super PAC. Stephen Colbert made his own super PAC. And you can put unlimited money into that super PAC and just make ads and trash somebody and trash a group or trash this, and it's fine. You can't be coordinated with the party. You can't do it, but money is speech. So the reason why I just don't want you to ignore this one, even though they say it's not going to be there because it's Unit 5, remember that Johnson Amendment question, and related to it, there might be something in there. Maybe not, but there might be a question comparing this act, because the Johnson Amendment was against churches. Churches can't, give to political campaigns. They can't be tied to it. They're restricted. Now, a lot of people were confused. The Johnson Amendment is not an amendment. It's a law. When you hear the word amendment, is that one of the 27 amendments? Probably not. The Hyde Amendment, which basically says the federal government in this law you can't give abortions to women using federal money. That's the Hyde Amendment. It is a law. It is not one of the 27 amendments. And a lot of people on their essays said one of the solutions was to do amendment to get rid of this. No, all you need to do is create a law, revoke the Johnson Amendment, do something like that. So
I put that. I'm stupid.
No, you're not, because you hear the word amendment. Just when you hear the word amendment, think about it and go, is this one of the 27? And most of the 27 are giving women the right to vote, giving blacks the right to vote, the 14th Amendment, giving 18-year-olds the right to vote. It's not one of those amendments. It's not one of the 27. It was just a law. So what the answer would be, what the solution would be is, have Congress pass a law revoking the Johnson Amendment or something like that. Does anybody have any questions on our documents or on the Supreme Court cases?
No.
Now, I've given you links. I've given you links to individual videos on each one of the documents and on them combined. Whatever you need to look at, but realize for that argument essay, it's going to be asking you about one of the documents, and then you can also use one of the Supreme Court cases or another law or something else with it. Remember, you do not have to use both of the required documents in your argument essay. So you don't have to do that. So let's see. We're going to do this again and see. So, come on, go away. So for me, my feeling for you guys is you're going to do great. Make sure you have your room without distractions. Tell mom and dad what you're doing. Whether you're dressed, feel good, shower, whatever you do, make you feel good. I get up every morning at 7 just because I feel like it makes me feel better. It makes me feel like I want to be ready to do something. Make sure you have your table, have everything together, everything around. I definitely I've heard a couple people say, no, lying on the bed, you'll fall asleep, you'll get lazy, that kind of stuff. I've seen that. Make sure you turn off your notifications on your phone, no social media, no talking to anybody else, and have your materials there. Now, I don't know if you agree with the 10 pages or not. I don't care, because I'm not you and I'm not organized like you. So if you've got 30 pages, but it's all got tabs and organized, that's fine. I just really believe that the documents you need to have in front first, because that's the argument essay. And then you need your Unit 2 notes or Unit 2 study guides or whatever you're going to have for Unit 2, which is, president, Congress, Supreme Court, the bureaucracy is going to be there, and then you can have 1 and 3 around there, so you can have that, but have your documents, your Supreme Court cases, and then Unit 2, and then just be ready, because you know that's what it's going to be. You got the whole hour. I would log in early, breathe, and just, you're going to do well. Make sure that you watch your time. Whenever you finish, submit it. Don't let the 5 minutes go by and you didn't submit it. You can still earn a 5 if you don't complete all of the questions and all of the things. Remember, if you fail to submit, you cannot retest. Minimize your distractions. Don't talk to anyone, me, you, anyone about the test questions after. They're going to get us answers pretty quickly, and we'll get it. We'll know that in a few days. Do not share your notes with anyone else. Make sure you have your own folder, your own tabs, but they're all in yours. Do not Google answers. Don't copy and paste, cut and paste. Now, I always, whenever I give an open book test and you've got a book, that's the worst thing. Unless you've got tabs, I really say use your notes, use your study guide, use what you have. Organize your notes, figure out what you want to do, and then go from there. What do you guys think so far?
About the test?
Anything, any questions, anything that you want to go over and look at?
No, I feel fine.
I feel pretty good. Better than I thought I would, honestly.
I'm kind of nervous about if they ask questions on framers or anything, just because, like, I don't know. I didn't take great notes on that.
Bobby, just remember that Harry Styles was a founding father. That's all you
So, first off,
Don't do it.
what is the question going to be on the framers?
I don't know. Anything with learning?
About federal power, like if they wanted it like that.
I mean,
Yeah, like how did they intend like a modern like thing to be, and like how did, or no, like they're like, how did they intend this to be, and then like how does it relate to modern day? Those stress me out.
I don't think.
But,
See, most of your founding questions and most of your questions that you might not feel comfortable in would probably be in multiple choice. That's not going to be an argument essay. You've seen the 2 argument essays. I've given you other argument essays. None of it say, what did the founding fathers think? Okay, so I really don't think they're going to get that nitpicky. It's got to be broad. It's got to be a broad question. In the argument essay, you can choose one side or the other. And you have to use the documents as your evidence. So I don't think they're going to be that picky. Like I said, the argument essay is going to be one, and then the other is going to be on some argument between Congress and the president, some scenario. And then you've got to say, what's the solution? What could they do? What would be the problem? And just realize you guys seem to ignore current events and like the Johnson Amendment. So what was the solution to the Johnson Amendment? Everybody got pass a law revoking the Johnson Amendment. Now, the second part to the question is, would it pass? What would partisan divisions do with the Johnson Amendment? So that's basically asking, will this law pass?
Wait, Mr. Guy, I have a question.
Shoot.
So with things like that, when they talk about like how the different ideologies would affect that, are they just taking, because obviously today everything is so split that it's like realistically too hard. Are they taking into account how it actually is, or just like in general their beliefs?
Well, I want you to give an example.
Okay.
But why not use what's here?
Yeah.
I mean, would the Johnson Amendment pass? No. The House is run by Democrats. The Republican is run by the Senate. Senate holds that. There's no way a bill about the Johnson Amendment will pass.
So we can tie in like what's actually happening in the government.
I would absolutely do that. They want an example.
Okay.
So instead of making up an example in your head and saying, well, if Congress was Republican and the president was a Democrat, the president would veto that bill. That's right. But just use what's going on today. Use what's happening today. That will never pass. You could also even say, it might not even pass the Senate because of the filibuster. You might have a Democrat senator against that amendment and, doing it. But what a lot of you had said was Democrats are against it, Republicans are for it. Well, that's true. But what if the Senate was all run in the House and everything was run by Republicans and it was, a 60% majority? It doesn't matter what the Democrats think. It doesn't matter anything. The Republicans are going to pass it.
Okay, because for those, I'd mostly just thought it was like take into account their ideologies, not what actually would happen like in the House or whatever. So that helps.
Well, it's about lawmaking.
Mhm.
So lawmaking is in the House and the Senate. And then when it says partisan, that's not ideology. That is Republican Democrat.
Yeah.
So when you hear the word partisan or party politics or party polarization, you shouldn't be talking liberals, conservatives. You should be talking Republicans and Democrats.
Okay.
And what's going to happen? Will this pass? Will this stop the president? What will happen on this? So party polarization, party division, divided government, all of that is Republican versus Democrat. And you can definitely get something on divided government. You can and use today. Would this law pass?
Okay.
Would something like getting rid of the Johnson Amendment pass? No way would it pass because Nancy Pelosi wouldn't let it. I mean, it just wouldn't happen. So that's why I'm saying use those examples. Now, let's go into this. Are we sharing? I'm not sure if we're sharing. We're not sharing. Let's share.
Is Exploding Cat still with you, Mr. Guy?
Yes, right next to me.
Perfect.
Yes. So on the first essay, always have the thesis and always say because, and then 1 to 2 reasons after that, take a stand. Don't always repeat the thesis. And I really would, word for word, you don't need to change it to something else. Use that one. Expanding power of the national government benefits policy making because blah, blah, blah. Then you need to have 2 pieces of information. Do not go to 3, 4, and 5. Just use 2. Describe it, explain it, related to the prompt, related to the thesis, and go away. Then do the second one. Again, describe it, give an example, then related to the prompt, related to the thesis, and then you're done. So on this one, develop an argument about whether the expanded power benefits or hinders policymaking. Most of you said benefit, and that's fine. Now, why would it benefit? Easier to pass laws, more efficient. Just it makes things easier and better because the articles were so terrible. A lot of you used articles and why they were bad. So you describe it and say the articles could not, tax could not raise an army. The articles could not regulate trade. Every state had their own currency. It was a nightmare. Shays Rebellion. A lot of you mentioned Shays Rebellion. Then after you say, those are the bad things in the articles, this showed the need for expanded powers of the national government that would benefit policymaking. You need to tie it together. You need to say, this showed we needed expanded powers. Then you need to say at the same time, this piece of evidence is basically proof that expanded powers of the national government benefits policymaking. Do you follow me?
Yes.
The last sentence in your paragraph, this proves, this shows that expanded powers of the national government benefits policymaking. This thing in the articles. Then you have to use a second one. Second piece, you do not have to use Brutus 1 or Federalist 10. You can use anything you want to. You may use Brutus 1, you may use Federalist, but you need to come up with another piece of evidence, describe it, relate it to how it argues that expanded powers benefit the national government in policymaking, and then it relates to your thesis. Most people lose points by not tying it to the prompt or the thesis. Most people have a thesis statement, that's 1 point. Most people describe it and do that well. For your argument, you get 2 and 3 points. Now you need to then tie it to the thesis and tie it to your prompt. Show that it works there. Adding a third piece of evidence doesn't help. Adding a fourth piece of evidence doesn't help. You need to have your 2 pieces, describe it, relate it to the prompt, relate it to the thesis. Okay? This one, it's explain, 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 explain. I gave people points for giving me a difference. This was with the churches, and this is with corporations and people, but really, these are explained, they're paragraphs. They're not 1-sentence answers. Any explain question is 3 to 5 sentences. Give an example. Congress can pass a law revoking the Johnson Amendment. The Congress can pass a law changing the Johnson Amendment, and then explain how partisan divisions could prevent this action. That's a lot of explaining. Difference is, here is about the Johnson Amendment, and then everything you know about Citizens United goes in the other part. Some people didn't even mention the Johnson Amendment. They just went over the Supreme Court decision, Citizens United versus FEC. You gotta mention the Johnson Amendment. This one, describe a liberty, freedom of speech, freedom of religion, whatever. It's a freedom of speech issue. It's about politics. It's about that kind of thing. So in this scenario, describe it, say it, and then what would they do? They would give a lawsuit. They would sue. They would make a lawsuit, because interest groups do that. They sue, and then they try to get it to be heard by the Supreme Court. They try to move it up because they believe that this is against the Constitution, the Bill of Rights, and they can even use Citizens United and say, well, this says corporations and unions have these rights. Why can't churches have these rights? And they could be right. Did you guys look at this one?
I didn't.
Did anybody look at it?
Not yet, no.
Okay. Well, it says develop an argument whether those interested in protecting minority rights should seek protection at state or federal level. So the thesis is those people interested in protecting minority rights should seek federal level because the 14th Amendment and past state laws, or 14th Amendment and civil rights laws, or they could look at should protecting minorities' rights should seat at the state level because of Brutus I and the U.S. Constitution. And Brutus I basically says, basically everything should be done at the state level, the local level. Your representatives know what the people want. The local representatives know what the people are. They know the people. One of the things he said is you should know your representative and you should see him at the store. The only representatives that are good representatives, they are ones you actually know and see. So to me, this screams as federal level. It really does. It screams federal levels, federal protection. Number one, the 14th Amendment protecting blacks and equal protection there, telling states you need to follow this. Civil rights laws had to be done through the federal government, not through the state government. You look at gay marriage, has to be done federally with the Supreme Court decision, not with states. Even Arizona had marriages between a man and a woman. So if you're protecting minority rights, it screams federal.
Could you even, and I know this might be a stretch, but if you did have something like this, could you even use Brown v. Board since every state did it differently? And then
Why wouldn't you?
It was like, no, you can't do that.
No, well, desegregation, segregation was by state.
Yeah, that's what I mean.
It was by state. So and the way we got rid of desegregation was through the federal level, Brown versus Board of Education. That could have been one of your cases that you would use.
Okay.
So you could use the Constitution and you can say applied powers, because that's how civil rights passed. You could say, or you could just say the Civil Rights Act was federal. But I always like the implied powers because that's in the Constitution, it's there. if you're using it. I would not use, well, maybe you would. Would you use Federalist 10? That protects you from factions. And what it said, Federalist 10 said at the national level, the large republic protects you. At the state level, you can have mob rule. So it's even saying at the state and small level, factions can control. And you can see that today. You can say, based on Federalist 10 and factions, you see factions at the local level discriminate against people. You can see local states, basically have, laws against blacks. They have the segregation laws, the Jim Crow laws. There's laws on the books right now in the South that say you can't rent to a gay person. It's illegal to hire to a gay person. Gay marriage is allowed, but there's still a lot of discriminations against gays in many states. So this screams federal, but you can argue every one, but you have to argue it. I'm not going to say which one you do, but you've got more there, but you got to use two pieces of evidence. You got to say this is showing that the federal government is protecting minorities, and you need to say that federal government is better than the state government at protecting minorities. Those interests should go at the federal level, and tie it to your thesis. Practice it, do it, go over it, time yourself. Or if you find that you're better off just going over the stuff, go over the stuff. And then here is number 2.
Wait,
Now
Mr. Clark, for the previous one, I know you just went over it, but how would you use Brutus 1 to support you said you'd use Brutus 1 to support federal
No, states.
level?
States.
Okay.
So if I'm doing state, I'm using Brutus.
Right.
I have to.
If you were doing federal, you'd use the U.S. Constitution.
U.S. Constitution or even Federalist 10, because Federalist 10 said the large republic protects you against mob rule. And at the local level, it described there would be mob rule. And you do have it in certain states. There's one-party rule.
Okay.
So
Thank you.
right now, you've got states, you've got Republican states in the South, you've got Democratic states in places. They might, one-party rule is dangerous. Okay?
Yeah. Thank you.
So here's this Reagan scenario. And this is basically, they made a declaration, they violated this thing. So this whole thing is going over the War Powers Act and doing this. And so it said, the district court stated that the Constitution affords the judiciary a very limited role in matters related to foreign policy and national security, stating that such matters are largely, if not exclusively, entrusted to the political branches. And many times you're going to hear a case where the Supreme Court does not want to get involved in political matters. The Supreme Court doesn't want to they talk about political issues. Let the executive and Congress do that. So that's what that's basically about. Now, referencing the scenario, describe the constitutional prediction principle that reflected in this statement, explain how this decision affects Congress's formal powers, access to the war powers. So read it, look at it, go over it, but these are all describe and explain. They are paragraphs, not one-sentence answers.
For those ones, would you recommend that we do ABC, like write out which one
That's
we're
fine.
answering, or just, okay.
It doesn't matter. They're saying this year it doesn't matter. You can just do different paragraphs if you want to, or you can do A, B, and C. It doesn't matter. What help do you guys need?
I personally think I'm good. This was super helpful, and I know we've been doing review for the past week, so I feel good. But
Ellie, Sabi, what do you guys think? What do you need from me? What do you need at all?
I think I definitely need to do like a practice of the essays again because
Okay.
I thought I had it going in on Friday or something, and then like actually doing it, the constructive essay, I like felt myself struggling.
Okay.
And I like messed it up. And like talking now, I'm like, oh, I really messed it up.
Okay. And that's fine. Just it's practice. So let's look at, see if I can find it. Let's see. All right, so, and I did it in 4 different things. So this is the essays. So if you want to practice those essays that I just showed you with the Reagan, with that Nicaraguan scenario, and you want to do that, and you want to do the other essay, that's fine. This is government review, and basically forget the top part, but down here here's unit 1 review, and then these are different ones that they have. This is questions, this is essay questions from unit 1, this is a Kahoot, and then your foundational documents, and then I have these on each document that you want to look at or that you want to do. Some are Khan Academy, some are whoever else. These are the required Supreme Court cases, and then I did an essay on each, a video on each case, or case that they've got, and then unit 2, unit 3, the constructive essay, the argument essay, and so on. Then let's see if I can get back out. Maybe I can't. You might want to do these. I have then given you unit 1, unit 2, unit 3 essays, all from Classroom. So this one has got 39 essays. This one's got 9. This one's got maybe 11, 21. So those are different essays. They just, if you want to look at what's it asking, just to get the style and look at it, can I answer that? Can I check that off? Can I do that? Do whatever you need to do. You might look at, I'm looking at, maybe you just need to know the format, get the format down, and just brush up on, the content, or have the content in a certain area, get organized. If it's going to say something about lawmaking, do you have how a bill becomes a law where you can see it? Does it have, if it says, what are the powers of the president? What are the powers of Congress? Do you have that in a nice little plate where you can see formal powers, informal powers? So it's your call on what you need to study, but you've got over 50 essays to look at. So if you want to look at the essays, look at the essays. If you want to look at the videos, look at the videos. If you want to organize your notes, whatever you need. Now, Monday during office hours, I'm basically giving everybody who didn't take the practice test, but I'll be there because I can't say anything. If you have questions, just shoot me some questions, or see, does this make sense? Or how does this sound? Or I have a problem on this document. I'll be there, and I can text anybody during that time, because I'm just going to be sitting there watching them do nothing. Because I've got about 20 people that need to remake the essay. Anything else from me, guys?
I'm planning on watching the movie about Ruth Bader Ginsburg on the basis of sex. I'm gonna watch that movie tonight because I feel like it'll motivate me.
Oh, she's amazing. She is hardcore amazing, and it just is. It's inspiring. And one of the complaints that Bill Clinton had was, is she too old? But when you're looking at anybody that has argued in front of the Supreme Court, she was like a knockout, because she had won 5, 6, 7 cases, discrimination cases. She had won cases for men, because men were like stay-at-home dads that doing stuff. And I mean, she didn't matter if it was gender, she won. And she argued in front of the Supreme Court. She knew it. She was perfect for it. But yeah, it definitely will get you motivated and get you going. But whatever you need, text me, email me, whatever you need to do, and I'm here for you guys. I'm going to send you a good luck video later on. So I'll post it on there, good luck, and everybody's going to think good thoughts and send you power thoughts between 1 and 2. So we all good?
Yeah, thank you, Mr. Guy.
You're welcome. Lauren, you good?
I'm so good.
Beautiful. So I have to look at your essays, but you actually know, based on what we said, what they were like, right?
Yeah, I think messed up with the second one, but I don't know. I
What do you
kind of
mean, mess?
with the constructive one for the when it's time off it would be passed. I think I focused more on like conservatives like less government intervention and more freedom
true.
of blah 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 blah
It's true.
blah.
It's true, but it's always asking you about passing the law. It's
Yeah, and I
always,
think I
I
kind
mean,
of strayed from that.
the constructive essay is always about the fight, it's interactions between the branches.
Yeah.
So it's the interactions between Congress, president, and judicial branch. So
Mhm.
there's always going to be something in that, like a scenario, and then what's going to happen. So what would happen with that? So that's why I always say if it looks at partisan party polarization, always look at Democrats, Republicans, and always give an example. You know, for anything, use civil rights laws, use Obamacare, use different laws use Trump's tax law. Whatever you need to look at, use it if it helps you. Okay?
All right. Thank you, Mr. Guy.
Bye,
Thank you
guys.
so
If you don't have anything
much.
else, you're
Bye.
welcome. Good luck.
Have a good day. Thank
You too. Bye-bye.